This video will give you a short explanation on how to get a green card for your spouse. Having represented thousands of immigrants, I believe that the foundation of every successful encounter with immigration is a detailed evaluation of your case. Now, while there are multiple prongs to the law, I'm going to break down 3 major points that absolutely always need to be considered. So step 1, you need to determine if there's an immigrant visa that is immediately available for your spouse. Now, if you're a U.S. citizen, then an immigrant visa is almost always immediately available. And that means your spouse would only need to wait while the case processes through the government's immigration system. Now, if you're a legal permanent resident that's petitioning for your spouse, then your spouse is subject to the preference system. And there are only 480,000 of those visas available per year for family members subject to the preference system. Your spouse would be assigned a priority date and would need to wait for a visa number to become available for him or she. Now, step 2 is that you need to determine where your spouse will physically complete processing of the green card application. There are 2 possibilities. One is an adjustment of status that allows your spouse to switch his or her status within the United States. The second one is consular processing, where your spouse is either located abroad already or they have to leave the U.S. to process at a consulate internationally. Generally, if your spouse entered legally or if they were paroled into the United States, then he or she should investigate whether an adjustment of status is possible, as that will be more favorable. Some other factors to include would be whether the petitioning spouse, being you, is a U.S. citizen or a legal permanent resident, and whether your spouse is out of status or they entered without being inspected by an immigration official. If your spouse needs to leave the United States to process, then I cannot stress the importance of meeting with an immigration attorney prior to your departure. Departing can have serious consequences to re-entry if your spouse is found inadmissible. And this brings me to the third part of the analysis. So step 3, you need to determine if your spouse is inadmissible. Inadmissibility is a fancy term that basically comes down to reasons or grounds for which immigration may deny re-entry or deny your case. And this can include anywhere from criminal grounds, public charge grounds, health grounds, immigration violations, and there are many other numerous grounds. The grounds of inadmissibility are all listed in Section 212 of the Immigration and Nationality Act. Now, when conducting this analysis, you need to consider all of your spouse's immigration and criminal history. And you should know that the immigration law directs officers to presume that your spouse is inadmissible. That means that the immigration law is set up for a denial being the default answer by the officers. It is up to you and your spouse to prove that you guys are admissible to the United States, that your spouse is admissible. And this is why working with an experienced immigration attorney can save you time, money, and heartache. Now, if you do determine that your spouse is inadmissible, then you also need to take a look and see if there's a waiver available that can waive that ground of inadmissibility. The waivers all have different standards, so reviewing that on this video is way beyond the scope. The actual immigration forms themselves for the entire immigrant visa process are available for free at uscis.gov and on the State Department website. For purposes of this video, I cannot give you an exact list because there are many different evaluations that are being done, and the forms that you will need will depend on the facts of your spouse's case and the answers to each one of those evaluations. This immigration analysis is the foundation of your immigration case and should not be left to chance. You want to determine what immigration laws apply to your spouse prior to filing anything, because the repercussions of a wrong filing can be a denial of the case, loss of money, loss of time, separation from each other in a different country, or even permanent removal from the United States. Now, if you want help with this evaluation, please feel free to call us at the number below.